Owen, bienvenido una vez más a la Universidad de Palermo.
I first met Carlos Nino in June 1985. At the time we met, Carlos was thoroughly engaged in the task of holding the generals accountable for crimes that they had committed in fighting what was then called the Dirty War. Everyone spoke of the generals' abuses of power as human rights crimes. But this phrase was only meant to indicate the seriousness of the offenses and the fact that the offenses were universally condemned. The generals were being prosecuted for violating the laws of Argentina and were being judged by a national tribunal. This prosecution was a remarkable endeavor, indeed of world historic significance, in large part because it, unlike the Nuremberg trials, was undertaken without the aid of a conquering army. Carlos and all of those with whom he worked, many of whom are sitting in this room this evening, were fully aware of the fragility, maybe even the impossibility of this endeavor. Their persistence was a reflection of their commitment to the rule of law and the belief that it was the responsibility of the judiciary to determine whether those who had once acted in the name of the nation had obeyed the law. I now return to Buenos Aires 28 years later. No Carlos, but with the lessons of the 1985 trials firmly etched on my soul. Carlos' absence from much of this period has been the source of a personal grief, one of almost immeasurable proportions. It has not, however, diluted, but only strengthened the lessons he taught me and added to them a certain poignancy. Carlos has not been with me as I've confronted the United States' own war. It's not called a dirty war, but rather the war on terror. And throughout this sad and turbulent period of American history, I have often felt engaged in a silent dialogue with him. Much like the Dirty War, the phrase war on terror has no discernible legal content. President George W. Bush coined the term for political purposes to mobilize the nation, but over time, the phrase came to embrace three distinct military operations. One is against Al-Qaeda, the international terrorist organization responsible for the terrorist attacks that occurred in the United States on September 11, 2001. A second war consists of the military campaign against Afghanistan, then ruled by the Taliban for harboring Al-Qaeda. The third is against Iraq, then controlled by Saddam Hussein, although Saddam Hussein had no role in the 9/11 attacks. The administration justified the invasion of Iraq in 2003 on the theory, soon disproved, that he possessed weapons of mass destruction. Yet the American troops that invaded and then occupied that country soon became the target of terrorist attacks, some by Al-Qaeda. This had the effect of turning Iraq into yet another site of the so-called war on terror. The military campaign in Iraq ended in December 2011 when the United States withdrew its forces from that country. As you know, plans have been set for the withdrawal of troops from Afghanistan by the end of 2014. And if those plans ever materialize, the war against Afghanistan will then be concluded. In recent years, the Taliban, once the group that controlled the Afghan government, has been treated as a distinct belligerent, perhaps as an ally of Al-Qaeda, and as a consequence, the war against the Taliban continues. So does the war against Al-Qaeda. In May 2011, Osama bin Laden, the self-declared leader of Al-Qaeda, was killed by a group of Navy SEALs who, in the middle of the night, penetrated his compound in Pakistan. But his death did not bring the war against Al-Qaeda to an end. In fact, that military operation remains, as it's always been, the focal point of the war on terror. Although President Obama has meticulously avoided speaking of a war on terror, he has persistently declared that the United States is at war with Al-Qaeda and its allies. Just this past May, apparently in response to the deteriorating situation in Guantanamo, a hunger strike that at its peak involved more than 150 prisoners, Obama delivered a speech at the National Defense University in which he openly contemplated the end of the war against Al-Qaeda. This war, he said, this war, like all wars, must end. However, in July and August, he launched drone attacks in Yemen and Pakistan against suspected members of Al-Qaeda. In so doing, he moved the nation in the opposite direction and indicated a willingness to continue, maybe intensify, the war against Al-Qaeda and the Taliban. The Buenos Aires trials of 1985 focused on the legality of practices that had occurred in a finite historical period that was then at an end. In 1983, there had been a regime shift, the end of a dictatorship, and the restoration of democracy. And the trials that occurred in Buenos Aires in 1985 were seen as a form of transitional justice. The judges looked backward and applied the criminal law to the generals. In contrast, there has been no regime shift in the United States, only a shift in administrations from Bush to Obama. And although there have been some differences in how the two administrations conducted the war on terror, these differences, in my opinion, are overwhelmed by the commonalities. Some of the lawsuits that arose in the United States in this past decade have a backward-looking quality, as, for example, suits for damages by victims of torture. But for the most part, the legal proceedings have challenged ongoing government practices. And the primary remedy has been either the injunction or the writ of habeas corpus. I fully acknowledge these differences in the circumstances that faced Argentina in 1985 and those that we in the United States confront in the post-9/11 era. Yet I find myself impelled by the same ethical demand that drove Carlos Nino: the duty to hold the highest officials of the nation accountable to the law. Over the past decade, the Supreme Court of the United States has been repeatedly asked to hold the government to the terms of the Constitution. Much to my disappointment, however, the Supreme Court balked. It dismissed the lawsuits without ever reaching their merits, or the court responded to the claims before it in an evasive manner. In these actions, I'm sad to report, the Supreme Court had undermined the system of accountability that has long been a proud part of the American constitutional tradition, and that was, in its own way, vindicated by the Buenos Aires trials. At issue is not a single isolated decision, but rather a pattern of Supreme Court decisions, a pattern that is at once persistent and corrosive, and that, in my judgment, constitutes a gross dereliction of duty. To give substance to this charge, and I appreciate the gravity of it, I need to describe the performances of the Supreme Court in 4 distinct areas. The first consists of the decision this past April, when the Supreme Court dismissed, without ever reaching the merits, a lawsuit attacking a grant of authority by Congress for the executive to engage in warrantless wiretapping. The statute in question, passed in 2008 and renewed in 2012, was intended to supplant the secret order President Bush had issued in 2001 authorizing the National Security Agency to intercept, without court authorization, the international telephone calls of anyone suspected of having links to Al-Qaeda. The lawsuit was brought by a varied group of individuals. Some actually were lawyers representing suspected terrorists about to go on trial. Others were journalists who regularly cover the Middle East and the government's counterterrorism activities in that region. Still others were researchers for NGOs, such as Amnesty International, dedicated to the protection of human rights. Because of the secretive nature of the threatened interception, you never know when your phone is tapped. None of these individuals could show that their telephone calls were in fact being tapped. They claim, rather, that there was a substantial risk that their calls would be intercepted. Although in one footnote, the Supreme Court, for reasons that I find difficult to understand, declared that the risk that these individuals faced was not substantial. The larger ambition of the court's opinion, written by Samuel Alito, was to craft a new standard for standing in national security cases. In such cases, he said, the plaintiffs have to show that the harm that they are complaining of was certainly impending. Such a standard would, in effect, render a surreptitious program of surveillance, like warrantless wiretapping, immune from judicial review. Justice Alito did not deny this possibility, but rather declared an indifference to it. A second dereliction of duty arose from the Supreme Court's decision on military commissions. In the past, the United States used military commissions to try war crimes. Typically, the tribunals were established in an active theater of combat and were composed of military officers who were appointed on an ad hoc basis by a commanding officer. The jurisdictions of these tribunals extended to the nation's own troops as well as enemy soldiers. Military commissions were viewed as tribunals of necessity, as a way of preserving the integrity of the laws of war in the midst of an ongoing conflict. At the very beginning of the War on Terror, President Bush issued an order establishing military commissions to try some of the foreign nationals held at Guantanamo. Whatever else might be said about Guantanamo, I can assure you it was not an active theater of combat. Yet the Guantanamo commissions were to be composed of military officers appointed on an ad hoc basis by an official of the Department of Defense. The procedural protections afforded the accused were significantly less forceful than those available in the ordinary federal courts. In addition, the public's access to the trial was limited. President Bush confined the jurisdiction of the Guantanamo commissions to foreign nationals, a limitation that not only offended equal protection, but also underscored the lesser quality of justice likely to be rendered by these tribunals. In June 2006, the Supreme Court rendered a decision on the legality of the Guantanamo commissions. Guided by a theory of minimalism, the court said nothing about due process, but held only that Bush's order establishing the military commissions violated a provision of the Uniform Code of Military Justice. Congress almost immediately and quite predictably responded to this decision by enacting the Military Commissions Act of 2006. It, in effect, endorsed Bush's initial order and put the mode of trial on firm statutory ground. The 2006 statute was further refined by the Military Commissions Act of 2009, a measure that President Obama sponsored and in fact improved on some of the evidentiary rules. Obama's revisions were wholly salutary, but they did not eliminate the affront to due process that adheres in an adjudicatory structure which vests in military officers the power to decide the fate of suspected terrorists, which allows a Department of Defense official to select the judges to serve, and which allows the executive to choose to utilize these tribunals whenever it chooses. To this day, the Supreme Court has not addressed this due process issue, although 2 military commissions have been appointed by President Obama and are now at work in Guantanamo. A third area of dereliction concerns the administration's policy and the failure of the Supreme Court to address Bush and Obama's claim that they have the authority to incarcerate members of Al-Qaeda and the Taliban for prolonged, indefinite periods, maybe for life, without ever charging these prisoners with a crime or bringing them to trial. Bush and Obama have sought to justify this policy as the normal prerogative of a belligerent, without recognizing the unusual nature of the war on terror. Specifically, that it is a military operation that embraces the entire globe and may go on forever. In June 2004, the Supreme Court ruled that American citizen Yasser Hamdi, who had been captured in Afghanistan in 2001 and then incarcerated in a naval brig in the United States, was entitled to an evidentiary hearing on his claim that he had been in Afghanistan for purely personal reasons and had not taken up arms against the United States. The court's ruling was a victory for due process, but was qualified in important ways when the moment came to fashion the procedural rules that would govern such a hearing. For example, who would have the burden of proof? The author of the court's opinion, Sandra Day O'Connor, went so far as to suggest that the evidentiary hearing could even be held before a military tribunal. An even more fundamental qualification of this constitutional ruling emerged when, in a companion case, the court refused to decide whether the administration's detention policy could be applied to another American citizen, one who had been captured in the United States. The case in question was brought by Jose Padilla. He had been arrested at O'Hare Airport in Chicago in May 2002, then transferred to New York, and from there to a naval brig in South Carolina. In a press release, the Attorney General of the United States claimed that Padilla was an operative of Al-Qaeda who had been sent to the United States to detonate a radioactive device. But Padilla was not charged with a crime, only incarcerated. By the time his habeas petition reached the Supreme Court, Padilla had been in prison for 2 years, and for the most part, he was held incommunicado. Rather than addressing the legality of his imprisonment, however, the court held that Padilla's lawyers had erred in filing his habeas petition in the federal district court in New York, as opposed to the one in South Carolina. Because the transfers from civilian to military authorities occurred surreptitiously, it's unclear whether the decision of Padilla's lawyers to file the petition in New York was in fact an error. But even if it were, this error in no way affected the capacity of the Supreme Court to speak to the merits of Padilla's claim or the legality of the government's detention policy. Padilla's lawyers followed the instructions of the Supreme Court and filed a new habeas petition, this time in South Carolina. In this second habeas proceeding, the district court ruled in Padilla's favor. The government decided to forego the opportunity to seek reversal in the Court of Appeals and directly petitioned the Supreme Court for review. Once again, the Supreme Court did not rule on the merits of the case, but rather directed the parties back to the Court of Appeals. That court reversed the district court and ruled in favor of the government. At this juncture, Padilla's lawyers once again sought review of the Court of Appeals decision in the Supreme Court. In November 2005, almost 3 years of incarceration had run. And just before the government had to respond to Padilla's petition, the government sharply reversed course. The government then charged Padilla with the crime, specifically conspiring to murder, kidnap, and maim persons in a foreign country, and also for providing material support to terrorists. No mention was made of a plan to detonate a radioactive device in the United States. The government then asked the Supreme Court to deny Padilla's petition for review and to vacate the judgment of the Court of Appeals as moot. In January 2006, 3.5 years after the initial arrest of Padilla at O'Hare, the Supreme Court granted the government's motion and dismissed the petition. In so doing, the court once again avoided confronting or in any way indicating disapproval of the government's detention policy or its blatantly evasive strategy. Jose Padilla and Yasser Hamdi were, as I noted, United States citizens imprisoned in the United States. One was captured in the United States, Padilla. The other, Hamdi, was captured in Afghanistan. Yet in a companion case involving foreign nationals who were being held at Guantanamo, a territory that the United States had occupied since 1903 and turned into a prison for the War on Terror in January 2002. The United States had obtained the lease as a result of the Spanish-American War. In the lease, Cuba nominally retained sovereignty of the territory, but it gave the United States the right to occupy Guantanamo without any limitation as to time. The question in this case was whether the Guantanamo prisoners were entitled to the protection of the writ of habeas corpus. The Constitution explicitly limits the circumstances under which the writ might be suspended by Congress, and in so doing implicitly guarantees the writ when these circumstances have not arisen and Congress has not affirmatively taken the necessary steps to suspend it. President Bush maintained, however, that the writ did not provide any protection to foreign nationals who were being held abroad. The Court of Appeals for the District of Columbia sustained this position, declaring, and I'm quoting, "We cannot see why or how the writ may be made available to aliens abroad when basic constitutional rights are not." Over the next decade, the Supreme Court did everything possible to avoid ever confronting the logic of the Court of Appeals decision. In June 2004, in a companion to the Hamdi and Padilla decisions, the court avoided the constitutional issue and held that the terms of the federal habeas statute were broad enough to allow the Guantanamo prisoners to petition for the writ. In December 2005, Congress, responding to that decision, narrowed the federal habeas statute and explicitly denied the Guantanamo prisoners the right to apply for the writ. The statute was not a suspension, but rather an outright prohibition. It raised obvious constitutional issues because it was restricted to one group of prisoners and was not predicated on the circumstances that otherwise would allow Congress to suspend it, a rebellion or invasion. However, when the validity of the statute arose before the Supreme Court, as it did in June 2006, the court, once again guided by the tenets of minimalism, avoided a constitutional ruling. The court simply held that the 2005 statute was not meant to apply to habeas petitions that had been filed before the statute had been enacted. In October 2006, Congress passed another statute, and in that measure denied the writ of habeas corpus to any foreign national, regardless of where he was detained, who had been determined by the executive to have supported al-Qaeda or the Taliban. By way of emphasis, Congress declared that this ban on habeas corpus was to apply to all pending cases without exception. This long saga over the availability of habeas corpus to the Guantanamo prisoners eventually came to an end in 2008, more than 6 years after the prison in Guantanamo had been opened. The court held in Bermudadine versus Bush that the ban on habeas enacted by Congress in 2006 was invalid, at least it was as applied to the Guantanamo prisoners. The court did not decide that these prisoners had any constitutional rights, and if so, what they might be. Rather, the court simply declared that the ban on habeas was an affront to the principle of separation of powers. On this theory, the only issue to be decided in the habeas proceeding was whether the prisoner had supported al-Qaeda or the Taliban. There was no indication that the prisoners would be able to use habeas to challenge trial by military commissions, or to challenge prolonged indefinite imprisonment without trial, or even to secure the release on the ground that they were being or had been tortured. The court also failed to give any guidance to the lower courts regarding the evidentiary rules to govern these habeas proceedings, nor did it lay down a principle for determining whether habeas would be available to other detainees who were confined to offshore prisons that were established as a part of the war on terror. These issues are now being fought out in the District of Columbia courts. The fourth and final area of Supreme Court practice that I need to bring to your attention, involves torture. When the war on terror began, a broad array of legal instruments, including a treaty, a criminal statute enacted to implement that treaty, and legal precedents interpreting the Fifth and Eighth Amendments of the Bill of Rights, rendered illegal torture by United States officials. There was also a general understanding that these laws were never to be breached, even in the most exigent of circumstances. Before 9/11, almost every American lawyer assumed that United States officials would never engage in torture, and we were all proud of this tradition. Starting in April 2004, with the publication of photographs depicting abuse of prisoners in the Abu Ghraib prison in Iraq, that understanding and the assumption on which it rested was shattered. This disenchantment further deepened upon the leak of internal government documents from the Department of Justice and the Department of Defense that legitimated practices long thought to be a form of torture. It soon became abundantly clear that torture, or to use the new fashionable euphemism, enhanced interrogation, had become an integral part of the war on terror. In December 2005, acting at the prodding of Senator John McCain, a victim of torture during the Vietnam War, Congress passed a broad statute prohibiting torture by the United States officials. President Bush rigorously campaigned against enactment of the statute. Eventually, he signed it into law. But when doing so, he issued a statement underscoring the fact that the statute provided no remedy. In that statement, Bush also declared that he would not let McCain's proviso interfere with the discharge of his duties as Commander-in-Chief. In his memoirs, published shortly after leaving office, Bush reported, or maybe proudly declared, that he had personally authorized the waterboarding of high leaders of al-Qaeda. Upon becoming president in January 2009, Barack Obama immediately issued an executive order banning torture, and he took 2 additional steps making it less likely that the United States interrogator would torture suspected terrorists. He made the CIA the subject to the Army Field Manual, and he closed the CIA's secret overseas prisons. Obama, however, has steadfastly refused to prosecute any official who might have been engaged in torture. He has also refused to establish a truth commission that might set the record straight or return torture to the realm of the forbidden. President Obama said he was not interested in the past, only the future, without understanding, as President Alfonsine did, that what occurs in the future will be partly governed by how one deals with the past. In the United States, the power to initiate criminal proceedings is vested exclusively in the government. So torture victims themselves turned to the civil law and sought to recover on their own damages from the officers who had used torture or authorized others to use it. These plaintiffs, three of which are most notable, primarily relied on the 1971 decision of the Supreme Court that allowed, without statutory authorization, individuals to sue for damages arising from the violation of their constitutional rights. All three cases involved the practice of extraordinary rendition, in which persons in the custody of the United States were sent to countries such as Egypt and Syria for interrogation under circumstances making it extremely likely that they would be tortured. The fact that the torture was outsourced to foreign officials did not in any way relieve the United States officials of responsibility for the torture that ensued, for it was the United States officials who sent the individuals aboard and relied on foreign nationals to inflict the pain and then to obtain the information that it wanted. In each of these three cases, the subjects of the rendition were eventually released, and they then brought damage actions against the United States officials responsible for the torture. Lower courts dismissed all three suits without ever reaching the merits of the claims. Two suits were dismissed on the ground that the factual inquiries that would be involved in the lawsuit would present an unreasonable risk of revealing state secrets. This third suit was dismissed on the ground that special factors, namely that the case involved military operations or the conduct of foreign affairs, warranted an exception to the 1971 precedent upon which the plaintiffs relied. In all three cases, the individuals subjected to rendition and torture sought review by the Supreme Court by writ of certiorari. And in each case, the Supreme Court declined to review the judgments of the lower courts. The certiorari jurisdiction of the Supreme Court is in fact discretionary, and in part reflects the impossibility of having the Supreme Court review all the judgments of the lower courts. A conflict among lower courts often acts as an especially compelling reason for the Supreme Court to grant the writ of certiorari. Admittedly, there was no such conflict in this instance. Still, there were other compelling reasons for the court to consider these cases. Although the lower courts had relied on earlier Supreme Court precedents in dismissing them, in each instance, the lower court extended earlier Supreme Court rulings and applied these rulings in a totally different context. Moreover, all three suits charged conduct by United States officials, interrogation under conditions of torture that appeared to be a pervasive feature of the war on terror and that challenged what was once a proud and sacred feature of the United States constitutional tradition. As with warrantless wiretapping, as with the use of military commissions, as with imprisonment without trial, The Supreme Court's unwillingness to confront the issue of torture left the individuals who had in fact been tortured without a remedy. There is every reason in the world to be moved by their plight, but my concern here is not so much with the injustices done to these individuals as it is with the breakdown of the system of accountability that these decisions represent. The tripartite division of the government into executive, legislative, and judiciary often leads to easy talk about checks and balances, and a vision of the judiciary as a check, or better yet, a counterweight to the political branches. Such a conception of the judiciary's role in the American political system, or for that matter in any democracy, is misleading. The function of the judiciary is not to balance, not to check, not to temper the action of the political branches, but rather to interpret the Constitution and determine whether the other branches have complied with it. The court's judgment, or even the prospect of such a judgment, may in fact constrain the political branches and in that way act as a check on them. But that is not necessarily so. Sometimes the court may legitimate or facilitate the action of the political branches. And even when it nullifies or sets aside that action, that constraint on the political branches emerges as a consequence of its judgment, of the judiciary's judgment about the legality of the action in question. My complaint is not in the broad array of cases I've just described. Warrantless wiretapping, use of military commissions, detention policy, torture, that the court failed to check the executive or legislature or otherwise failed to act as a counterweight, but rather that it failed adequately to determine the legality of these practices. Carlos Nino was a lawyer, but even more, a Democrat. And his commitment to the Buenos Aires trials were in part driven by the fact that the court Alfonsine had assembled was judging the work of a dictatorship. Nothing like that could be said of the post-9/11 era in the United States. Questions, which I'm sure you're all familiar with, questions have been raised about the democratic legitimacy of Bush's initial election in 2000, but not to his election in 2004, at a time when some of the alleged abuses, including the use of torture, were well known. Moreover, Obama's democratic credentials are impeccable. In 2008, he campaigned on a platform of change, and many of those who voted for him, including myself, thought that this change would entail a wholesale repudiation of Bush's counterterrorism policies. We have been disappointed. But this disappointment should not be understood as an electoral breakdown or as a democratic failure. Remember, also, Obama was re-elected in November 2012, and not surprisingly this time around, after all the troubling policies that I tried to describe were in place, and there was no talk of changing these policies. The democratic pedigree of some of these counterterrorism policies have been further enhanced by repeated interventions by Congress. Congress endorsed wireless wiretapping in 2008 and renewed it in 2012. In the Detainee Treatment Act 2005, Congress denied the writ of habeas corpus to the Guantanamo prisoners. In the Military Commissions Act of 2006, it expanded the reach of that ban on habeas corpus and authorized the use of military commission. In 2009, Congress refined some of the procedures used by the military commissions, but in general, further legitimated this mode of trial. Moreover, throughout this entire post-9/11 era, a vibrant civil society as operated in the United States. The president was watched by Congress, and both were watched by the press, various NGOs, a large number of university professors, and a bevy of lawyers within the executive branch referred to as inspectors general. These institutions and agencies and their aggressive tactics enhance the democratic character of the counterterrorism policies that have emerged and that have now been endorsed by President Bush and Obama. In a recent book, Jack Goldsmith of Harvard pointed to the constraints that operated on Bush and Obama over the last decade. Goldsmith acknowledged the role that the judiciary played in the post-9/11 era, but he did so only grudgingly, and for the most part viewed the lawsuits that had been commenced as an instrument that enabled the NGOs to air their views publicly. It mattered little to Goldsmith that the lawsuits that these organizations had filed were dismissed by the Supreme Court, or that the Supreme Court responded to their claims in a limited and, in my view, unsatisfactory way. In describing the constraints on Bush and Obama, Professor Goldsmith's primary emphasis was not on the judiciary, but rather on the role of the civil society watchdogs, such as the media and the NGOs, on the inspectors general, and on Congress. It's important to understand, however, that Goldsmith's point was not merely to contend that Bush and then Obama have been constrained in formulating and implementing the counterterrorism policies, but rather to insist that by virtue of these constraints, the counterterrorism policies that have evolved over the past decade, the new normal, are legitimate and even more lawful. In reaching this conclusion, Goldsmith relied upon a political or evolutionary conception of law. He assumed that the new normal rested around a popular consensus which rendered the new normal constitutional, when in truth the so-called consensus was nothing more than a reflection of the current distribution of power between conflicting and antagonistic sources. Goldsmith's error was to infer legality from stasis, and in so doing he provided no basis for determining the constitutionality of various policies or practice prior to the achievement of stasis. Of course, someone can always complain that the President or Congress actions are abusive or excessive, but the critic can give no legal content to these terms, since according to Goldsmith, what is constitutional is nothing more than what happened to have evolved from political struggles, provided these contests are democratic in nature and involve the people as a whole. At his core, Goldsmith denied that the Constitution is a body of transcendent principle that needs to be interpreted and applied by some authoritative agency. For him, what is constitutional is simply what the relatively more influential or powerful groups within the demos come to accept as legitimate. I can't imagine Carlos Nino embracing Goldsmith's conception of law, but he came perilously close to doing so when he considered in Radical Evil on Trial the alternative road taken by Uruguay in its quest for transitional justice. When I arrived in Buenos Aires in June 1985, I had little to offer Carlos by way of advice. I did not know anything about Argentine law. I did not know anything about Argentine history. I did not even know Spanish, no todavía. All I had to offer was Brown versus the Board of Education. I was indeed proud of that decision and what it meant for American society, and I claim that it was the embodiment of the more transcendent conception of law. The court's function in that case, I said, was to give concrete meaning and expression to the constitutional promise of racial equality, even if that meant invalidating the laws of 17 states and the District of Columbia, even if it meant repudiating the settled understanding that then governed the White House and Congress. Carlos did not reject this transcendent conception of law, but he maintained, let's put it diplomatic, but he maintained a certain distance from it. Although he was, as I said, dedicated to the ongoing trial of the generals, he advanced an instrumental conception of those trials. They were valuable, he said, because their contribution to the restoration of democracy. The organized, precise, and public examination of the actions of the generals and the official judgment by a court of law about the legality of that action, he believed, helped define the character of the new regime and lay its democratic foundations. If, however, this is Carlos speaking, if, however, as appeared to be the case with Uruguay, democracy can be restored by other means, if the citizen, after full and open debate, decide to forego trials and grant their dictators immunity, there was no reason to object. The human rights trials for Carlos Nino were instruments, and like any instrument, they can be dispensed with when other means are found for achieving the same end. For me, however, a democratic resolution, even one fully accepted by the both political branches, and even one supported by a broad consensus, does not settle the issue of law. The court must still speak. Admittedly, the judiciary does not have an exclusive claim to interpreting the body of principles enshrined in the Constitution. The Constitution is a broad charter of governance, and the political branches, indeed all political forces, have an obligation to determine whether their action comports with it. In the course of the war on terror, the political branches have often been derelict in discharge of this duty and have not given a proper regard to the Constitution. This was the case, in my judgment, in the decision of the executive to utilize waterboarding and other interrogation procedures almost universally condemned as torture. Lawyers within the executive branch, such as John Yoo and William Haynes, wrote legal memoranda designed to tell the President and Secretary of Defense what they wanted to hear, not to provide an independent assessment of the law. The failure of the political branches to properly and seriously consider the legality of their actions was also manifest in Congress's decision in 2006 to deny the writ of habeas corpus to any foreign national determined by the executive to have supported al-Qaeda or the Taliban. Senator Arlen Specter, head of the Senate Judiciary Committee and a distinguished graduate, yes, of the Yale Law School, concluded that this statutory ban on habeas corpus was unconstitutional. But in the end, he voted for it. He left it to the court to invalidate the law, which it in fact did 2 years later, though in a case that is not worthy of a court of law. Let us assume, however, that the examples I just described are aberrations, and that the President or members of Congress generally had made a good faith effort about the constitutionality of each measure in question. Arguably, this has been the case with the 2008 statute that authorized warrantless wiretapping, since the grant of power was limited to cases where the target was a foreign national located abroad, and a significant purpose of the wiretap was to obtain foreign intelligence information. I would nevertheless argue that this congressional judgment does not lessen the need of the Supreme Court to judge the validity of the statute, or to excuse the recent decision of the Supreme Court to dismiss a case against the statute for lack of standing, or even more, to express, as Justice Alito did, an indifference to whether the constitutionality of that statute could ever be reviewed by a court. In saying this, I'm drawing a distinction between exclusivity and authoritativeness. The court is not the only institution that can interpret the Constitution, but it is the only one that can give it an authoritative interpretation. The authoritativeness of the court's interpretation does not derive from the personal qualities or moral character of the justices. Rather, it stems from the political insularity of the judiciary and the fact that the exercise of the judicial power is governed by what I have elsewhere called the strictures of public reason. The judiciary must hear from all aggrieved persons. The judiciary must openly address the arguments made by the parties. The judiciary must publicly announce its decision, and the judiciary must justify that decision on the basis of principle. The judiciary's independence from politics and its adherence to the strictures of public reason is, in my view, is instrumentally connected to arriving at the right interpretation. These features that govern the exercise of the judicial power make it more likely than not that the judiciary will correctly interpret the Constitution. Though they do not guarantee it, mistakes are always possible. If the question is not whether the judiciary has reached the right answer, but rather whether its answer is the authoritative one, then I maintain that its political insularity and its adherence to the strictures of public reason play a constitutive as opposed to an instrumental role. When it comes to interpreting the Constitution, the judiciary can override an interpretation of the political branches and claim that its view is authoritative simply by virtue of its political insularity and its willingness to abide by the strictures of public reason. This authority does not, however, create a privilege for the judiciary to abstain from rendering judgment on the law whenever it deems abstention is appropriate. While the judiciary must control its docket through the exercise of certiorari to avoid being swamped by an overload of cases, it has a responsibility. It has a responsibility to address practices such as extraordinary rendition that degrade the most elemental principles of the Constitution. This duty arises from the court's place within the structure of government as the guardian of the Constitution, and it arises from the court's unique capacity to generate authoritative interpretation. The reluctance of the Supreme Court to review the work of the political branches does not operate across the board. Indeed, Justice Ruth Bader Ginsburg, in an interview with the New York Times, recently labeled the current Supreme Court as one of the most activist courts in history. In making this charge, Justice Ginsburg primarily had in mind the recent decision of the Supreme Court invalidating a crucial provision of the Voting Rights Act of 1965. What distinguishes such a case from the ones arising from the War on Terror that I've surveyed at the outset of this lecture? What is the difference? Admittedly, the court has long deferred to the political branches in cases involving military operations and the conduct of foreign affairs. But that itself is a distinction that requires justification. Some have sought to justify the selective deference of the Supreme Court to the political branches in terms of expert knowledge. The idea is that military operations and the conduct of foreign affairs require expertise that the judiciary does not possess. In truth, the knowledge required in these cases is no more impenetrable or complex than the knowledge required in reviewing other activities of the modern state. For example, running a school system, or a prison, or a police department. Moreover, and this is important, the judiciary's task in all these cases is not to second-guess the executive or legislative branches on factual matters or in making a judgment about the best policy for the nation. The judiciary's task is only to determine whether the Constitution has been violated, surely not a matter that lies within the expertise of the political branches. In making the judgment whether the political branches have respected the bounds of the Constitution, the court can assume that the factual predicates underlying the action of the President or Congress are correct, and that the challenged policy or action that these branches have adopted serves the public interest. The court may assume, for example, that there is need for unfettered power to wiretap, or that the suspected terrorist possesses useful or valuable information and the imposition of excruciating pain by cutting off a finger, by depriving the prisoner of sleep, or simulating the sensation that he is drowning, will lead the prisoner to yield that information. The court can assume all of this is true, but then it proceeds to the more difficult normative judgment of determining whether the Constitution permits such action. Admittedly, the judgment of the court may prevent the political branches from pursuing the policy that it deems best. But this constraint flows from the Constitution and the authority of the judiciary to interpret it, not with the judiciary's disagreement with the judgments of the political branches about the facts or the public interest. Aside from any claim of expert knowledge, deference to the political branches in cases involving military operations or foreign affairs might be justified in terms of the harm at stake. Constraining the political branches, even if the constraint is fully justified by the Constitution, might result in catastrophic harm. We usually associate the risk of such harm with wars, but as we've learned over the last decade, there are many different kinds of war. Some place the very existence of the nation in jeopardy. That was indeed true, in my opinion, of the Second World War or the American Civil War. In these instances, I may be willing to assume, borrowing a formula from Carlos Rosencrantz, that power precedes legality, not the other way around. I would insist, however, that the military campaign against Al-Qaeda or the Taliban, or even the invasion of Afghanistan and Iraq are not wars of this type. There is no threat to the existence of the nation, and thus no risk of the catastrophic harm of which Carlos Rosencrantz spoke. Bruce Ackerman has objected to using the term war to describe military operations against terrorist groups such as Al-Qaeda or the Taliban, because these groups do not pose an existential threat to the United States. That's not my view. The phrase war on terror might be, as I said before, dismissed as nothing more than a technique for political mobilization. But the military campaign against Al-Qaeda or other terrorist groups might probably be considered as war, provided we recognize how unusual these wars are. They entail prolonged military operations in a foreign land, but differ from the other wars because of the absence of any readily perceivable geographic or temporal bounds, and because the alleged enemy poses no realistic threat to existence of the nation. This is not to deny the very real and painful harm inflicted by terrorist organizations such as Al-Qaeda and the Taliban, but only to maintain that this harm is not of the catastrophic quality that might justify abandoning the quest for legality or letting up on the demand that the political branches be held accountable to the law. In the war on terror, legality precedes power, and often, as we in the United States have learned, legality is a source of power. To draw a distinction between a war that poses an existential threat to the nation and a war against a terrorist organization such as Al-Qaeda or the Taliban, and in this way resist the reversal of power and legality, is not to minimize the deep and sorrowful harm that terrorists can inflict. The death and destruction that occurred on September 11, 2001, or that subsequently occurred in Madrid, or in London, or in Kenya just the other day, testifies to the painfulness of the harm that can be wrought at the hands of terrorists. Indeed, some have said that the loss of lives and destruction of property on September 11 was even greater than that which occurred to the United States in Pearl Harbor on December 6, 1941. The harm inflicted by terrorists should not only be measured in material terms, but also must take into account the fear that terrorist attack imposes on the entire civilian population. You never know when or where the next attack will take place and whether you might be a victim of it. The production of fear, this kind of fear, indeed is one of the defining features of terrorism, which is violence aimed at terrifying a civilian population. This element of fear, in my judgment, provides additional reason to guard against such attacks and to suppress organizations such as Al-Qaeda or the Taliban that may be responsible. It also gives us an additional reason to be distrustful of popular sentiment or the judgments of the branches that are responsive to that sentiment when choosing the means to fight terrorism, and even more when deciding whether those means are lawful. Yes, Carlos Nino was a Democrat, a very deep Democrat, but it must be understood that he valued democracy for epistemological reasons. Democracy, he said, gives voice to the widest ambit of perspectives, and in that way most nearly approximate the universal or impersonal vantage point required for ethical judgments. Whatever the validity of this theory might be in other situations, we can see, if Carlos would forgive me for one last departure, we can see the flaws of this theory in this time of terror, where large sectors of the public live in fear of becoming a victim of some almost random act of violence. Until 2012, this fear engendered by the 9/11 attacks was constantly renewed by periodic red or orange warnings issued by the president. Now the 24/7 news cycle fills that void. Of course, judges are subject to these same psychological dynamics. They too have been in the grips of the fear engendered by 9/11 attacks and all the other attacks that have occurred over the past decade. But the assumption is that judges will be disciplined by the strictures of public reason, above all by the need to publicly announce their decisions and to justify them on the basis of principle. And that through this discipline, They will work through their fears and perhaps move beyond them. The assumption is that these judges may be able to get to that impersonal vantage point of which the moral philosopher could only dream. In this time of terror, the judiciary may be uniquely capable of the impartial judgment that is of the essence of law, and the reason that Carlos Nino, always the moral philosopher, admired it so much. Thank you very much.
Bueno, ¿me escucha? Bueno, muchas gracias, Owen. It was
De nada.
amazing. And we will open the floor for questions. I'm sure there are a few. I could hear the questions being elaborated through the speech. So I think the first one that I heard from there was Martin.
Out loud. Hola. Owen, just a minor thing about the Nino position on Uruguay and Argentina. I think the difference between Argentina and the U.S. is that he thought that there were no rights in question in criminal law. Nobody had a right to see somebody in prison. I think that was his idea. You are talking about rights.
I'm talking about a very different kind of right.
Yeah, very different kind of right. That's why I think he should say that the Uruguayans have the right to democratically decide impunity, whereas the Americans do not have a right to decide on letting the people's rights be violated in Guantanamo.
We can answer first. You answer each question.
I'm not sure, Martin, that I follow the distinction, because if that's the defense of Uruguay, you could make the same defense of not doing anything about the U.S. policies. No one has a right. No one has a right. I mean, take torture in the United States. You could say, well, it's okay. Obama didn't prosecute anyone because no one has a right to see another person in prison. So what's the difference?
The idea is that since criminal law is a public policy for Carlos, the question there is whether the people in Guantanamo has a right to be freed. Then there's another issue whether you have the obligation to put Bush in prison. But I think what you're talking about is that the people in Guantanamo has a right to be freed, or at least to due process.
Yeah. And the victims of the dictators of
don't
Europe
have a right to see the dictators in prison. That's what I
well,
think
but
Carlos would say.
that puts it too glibly. I mean, the victims of the dictators.
Other things.
Excuse me?
You can do other things.
No, but you could have the victims of the dictators of Uruguay have a right to. I mean, say a torture victim of the dictators of Uruguay have a right to have their right not to be tortured to be vindicated. You don't have to characterize it as a right to put someone in prison. They have a right to have their constitutional protections or legal protections against torture vindicated. I mean, it's the characterization that all that's at stake is the right to put someone in prison. Of course, that doesn't sound very appealing, but that doesn't seem to me the only way to characterize what the action is.
Owen, first, thanks so much for the wonderful presentation. I want to ask something about the role of public intellectuals like you or Carlos, and particularly in the face of a court like the U.S. court that has been almost 50 years undermining Brown versus Board of Education and the legacy of the Warren Court. So, I mean, how to face that? I mean, what to think about that? So, should the public intellectuals work for a different conception, for a different interpretation, or should take a different understanding? Because, I mean, there have been 50 years of a systematic way of undermining Brown versus Ford, that legacy. So the question is what to do. And I think that, in a way, your answer, I mean, goes back to something that we know, which is that I would say, a kind of a rosy picture of the judiciary. I mean, the strictures of the public reason. Well, we could say something similar about a rosy picture about the Congress. I mean, well, if Congress, I mean, went through a process of democratic deliberations, things would be different, yes, and would be more legitimate in terms of equality, perhaps. So I'm wondering what to do. I mean, so just to argue for, I mean, with the hope of forcing them to adopt a different conception of a different interpretation of the law. I mean, finally they will stick to the law.
It's a very, that's a very deep, I'm sorry, it's a very deep and moving question. I feel that we should separate it a little bit. I feel that it's my responsibility as a teacher to teach my students that the new normal is not normal. I mean, the greatest danger that we face from this period is that we lose sight of our bearings. We come to accept things that were unimaginable, just absolutely unimaginable. And my students are coming into law school not knowing, I mean, they know something was going on. Probably they were born a little bit before 2001, but they know something is going on. And I feel it's my duty as a teacher, forget about the public intellectual, I feel it's my duty to educate them. You know, I've written about a lot of different subjects, most of which I'm very familiar with, Roberto. I never dreamt in my life that I would write about any of these subjects. Ever. But when the war on terror began to unfold, I began to become an expert in the Geneva Convention or torture convention and stuff like that, because I felt I had a moral duty to my students to sort of be a critic. Now, I'm not sure, the other part of the question is, what about and I'm sorry, let me just slow it down. And I feel about the same way about Brown versus Board of Education. I mean, my duty, I fear, is that I should explain what are the foundations of it, and hold on to them and teach my students of what the golden years were. Some of my colleagues who I respect have a different mission. I mean, they're now trying to, there's, I'm sorry to bore you with these details, but there is a debate between anti-subordination, you heard it yesterday, anti-subordination and anti-discrimination, and one of my dear students thinks that anti-subordination is doomed with the present court, so she constructed a new theory called anti-balkanization that is supposed to be appealing to the Kennedys, Justice Kennedy types. Well, I don't feel, that's not my job as teacher. My job as a teacher is to discover the truth about the law and to tell my students about it and make sure they don't confuse what they're living through with what the law could have been. Carlos was a public intellectual. I'm not a public intellectual. I mean,
come on.
Well, I write and I speak and I do it through my students, but I don't, my prospects of transforming the court don't motivate me. I don't get up in the morning thinking, well, is this going to make a difference of the court? I mean, I criticize what they did. I try to explain it and systematically. Sometimes you break through, and a lot of times you don't. I mean, as you said, since about 1974, 1975, 76, the court has been engaged in a process of sort of undermining what I think Brown really stood for. And I've, spoken about it many times, but I think, I don't know. I mean, I don't think you should sort of wonder if it's going to make a difference in the court. You just have to sort of call it as you see it, really.
For those who are not on this side, I can tell you about the faces of the students when he mentioned the students. So, Luis. Hay traducción, así es.
Bueno,
En inglés quizá para ellos.
it's a pleasure, Owen, you are here. And
Ponete más cerca.
I don't know if people realize in this room how courageous is what Owen say here. I don't know any of the professors in U.S. who is saying what Owen is saying. Harold Koch, who was the dean of the law school and was a liberal international lawyer, will be completely against Owen. So, and I like to follow the idea of Roberto Gargarella about the role of scholars. My feeling is not about what the court should do. I really believe the real issue here is the war on terror. You are killing people outside the U.S. territory. That's why for the lawyers in U.S., it's irrelevant. Because it's not your country. They are the enemy. That's what I remember in the discussion I had with the general in those days, in '85. I told him, General, you cannot convince me that you were killing and torturing people to defend freedom and democracy. And he said to me, but prosecutor, these are our values. They are the enemy. So killing and torturing enemies is okay. In Argentina, the problem is the enemies were also Argentinians. When killed and tortured in Argentina. So legally, it was no problem for us. But the problem in the U.S. is they don't believe in the law outside U.S. border. And it's Verdugo Enrique's decision, Albert Machain decision, it's there. So that's a problem. That's why Owen is the only law professor in U.S. talking about that. And I agree with you, scholars should talk on that, and they are not. But it's not about what the Supreme Court should do. It's how we can control terrorism in a proper way, in a legal way. How to be efficient with the law. That, for me, is the missing idea here. Because when in the U.S., they clearly feel it's not about the U.S. And it's funny, in 1945, Robert Jackson, the Nino prosecutor, said that. He said, we need to learn that we need to build a law among nations. Because if we're in a permanent war, our civil rights will disappear. We have no constitutional right in a permanent war. He said that in 1945. And that is what happened, you describe it. So the real issue is not what the Supreme Court could do. They cannot stop this. Obama has no idea what to do in international relations. It's obvious. Syria case is obvious. He defined this, look this, he defined this border that Assad in Syria cannot kill people with chemical weapons. If he killed 100,000 people. So, but if he killed people with normal weapons, that's okay, not a problem. So, and I feel we Argentinians should understand that and help to build the global system. It's not just about the national system. We are discussing constitutional right. It's not about constitutional right. It's about, can we develop rules for the world? Because that is, for me, the issue. That's why when you are talking, you're alone in the US. How to do that? Maybe you can tell us how to do that.
Well, first of all, thank you, Luis. I have nothing to say about building the global system, but I want to make 2 points. One point is, it's not true that we're only doing it to outsiders,
Mostly.
mostly. But as the case of Jose Padilla
Yeah, yeah.
and Hamdi, but I mean, the Padilla case is some kind of outrage, really.
Yes.
I mean, because they did it not just to an American, but an American who was captured in the United States.
Yes.
Who was captured in the United States. So it's something's wrong with the system where we can't get our hands on that and address it. But as you say, most of them are foreigners located abroad. But I don't know if this would have changed into a global understanding, but what had to be understood was that what is at stake is not just the rights of foreigners abroad. That's not a proper way to see it. What has to be understood is the action of United States officials. These actions are being done by officials of the United States. And what has to be understood is that wherever they act, and against whomever they act, they are bound by the Constitution. And that is the thing that the court doesn't engage. You see, it got close to it in the Guantanamo habeas, but it just went off track altogether. But it seems to me that what's missing, and I may be the only person in America saying that at this time, but it was once a proud tradition of the United States Constitution. In the 60s, in the 50s, it was understood, mainly spearheaded by Justice Black, that wherever United States officials act, and against whomever they act, they are bound by the norms of the Constitution. Now, that may not solve the global system, I understand, but it seems to me that's what needs to be created. That's the issue that was posed by Guantanamo, consistently.
Verdugo Enriquez changed that. Verdugo Enriquez changed clearly that. No, Alvarez Machain, in this case, is in the Mexican case. It's Supreme Court say that. The Supreme Court say that in Verdugo Enriquez. They say the American officers are not limited by the U.S. law outside the U.S.
Yeah. Well, I believe it's my duty as a law professor to explain why that case is wrong. And also to explain that the opinion that you're referring to, which is Justice Rehnquist's opinion, never had 5 votes. I mean, we treat it as though it's authoritative, but that was a repudiation of an earlier tradition, and he didn't have the 5 votes to support his opinion. But Verdugo Enriquez is constantly cited for the proposition that you say that, but I think we need to challenge that. We need to confront it.
I like that.
Martin Sabin.
Hi, Martin.
Thank you. I want to echo what Luis said, which is that we're all very grateful that you are the voice in the wilderness in the United States, crying out and reminding us of this. I want to make an observation and ask a question, and I'll be
Okay.
as brief as I can because I'd really like to hear your answer. The observation is that you've chosen the best in the United States tradition, and you've held it up to us as a mirror. This notion that you've just assigned to Justice Black and to others that United States officials are governed by the Constitution and should be wherever and whenever they act. There is a darker tradition to the United States that many of us in Latin America recognize. It is a coincidence but informative that September 11th is not only the date of the attacks on the Twin Towers in New York, but also the date that Henry Kissinger and Richard Nixon backed the Pinochet coup in Chile. So there is a darker tradition that we should not forget, because in forgetting that tradition, we somewhat absolve ourselves in the United States of issues that we need to take responsibility for and possibly make it easier to fall into that pattern again. So that's the observation I wanted to make. The question I have for you has to do with this distinction that underlies your talk tonight, which was extremely illuminating to me, even though I live in the United States, and it's given me an entirely different perspective. But the question I have is, from where do you derive this distinction between the consequences of an existential war on the one hand and what you call it, what we could call a non-existential war on the other. That seems to underlie the entire framework of the message you gave us tonight. In other words, there are certain things that possibly are constitutional when there is an existential war, a war that challenges the very existence of the United States, and other things that are not, and those things are not permitted when we have a non-existential war. And the concern I have about that, Professor, is the following, that if the United States Constitution vests, as it does, such a strong authority in the president to decide foreign affairs, I'm afraid that courts are going to cede that decision, what is an existential war and what is not an existential war, to the president, and that thereby undermining what you're trying to help us with tonight, which is to reimpose constitutional limitations on what the executive can do, even if Congress backs it. So the concern I have is, if you are setting up this dichotomy, what are the roots of this dichotomy that we can ensure are respected so that this dichotomy is not simply decided by the president?
Well, I was a little bit responding to an article by Carlos Rosencrantz that appeared in Texas Law Review maybe a year or two ago, where he tries to argue that there is a relationship between power and legality, and that in certain catastrophic situations, the ordinary relationship between power and legality or legitimacy has to be reversed. I was trying to. I'm sorry. I was trying. You'll have to move an inch. I was trying to bracket that. And I tried to be careful in doing so. I'm not sure how much we ever get to that catastrophic situation where the power and legality reverses. What I wanted to say, and that's been a real feature of this war on terror, which has now gone on for a decade, that we have to have, and appreciating the harmfulness of terrorism, that we have to realize that this is not the occasion to reverse the ordinary assumption that govern us between power and legality. But I'm not sure. I'm not quite sure. In this context, a lot of reference was made to a case called in the Quirin case, which was decided in 1941 or something like that in the midst of the war. I'm not quite sure what I would have done there, confronting what the stakes of the war were. But I want to say that what we need to understand is that although we use this rhetoric of war, that this is not what we're dealing with. We're dealing with a problem, but not a problem that would justify this kind of reversal. Now, your question is a good one. Who should be making this decision? I don't see it in the political branches. I don't see it being made in the political branches. I would imagine that this too has to be made by a court. I appreciate fully what Luis and Roberto said about the present court, but I don't know. Sometimes I think this is the way it has to be. What's the alternative, really? What's the alternative?
¿Alguien más? Bueno, creo que fueron 2 días intensos. Bueno, mis primeras palabras antes de concluir son de agradecimiento.
I have one more word.
You have one more word? He wants to have the last word always. It's part of the... So before I finish, you want to...
Well, I basically, coming to Argentina and being part of this group and seeing a new generation of students again has always been, a great pleasure to me. It's now, almost 30 years that it's been an important part in people coming to New Haven or to Salem and stuff like that. But I've always appreciated the fact that you have held up a mirror to me. I mean, that is to say, I came and gave a lecture about America, but I was writing it, I was thinking about Carlos, but I was thinking also about you, and I'm grateful for the opportunity, not just the opportunity, but the challenge of presenting to you my reflections on an experience, knowing that you have another experience that forces things to the surface that I otherwise wouldn't have understood. So I thank you all very much for the opportunity. It's been almost 30 years in making, but it's been an important part of my life, and I thank you for it.
Can I now?
La última palabra.
No, iba a decir que, bueno, el primer agradecimiento es para Owen. Cuando surgió esta idea en la facultad, el primer llamado que hicimos fue a Owen para ver si tenía ganas de participar en una conversación como esta en honor de Carlos, y su respuesta fue inmediata, como siempre, y no solo eso, sino que se comprometió a escribir algo especialmente para discutir aquí, y como ustedes saben y habrán escuchado, ha estado trabajando intensamente los últimos meses solo para poder participar con nosotros en esta conversación aquí, así que mi primer agradecimiento es para Owen. Muchísimas gracias. La segunda cuestión es que durante los 2 días de conversación mucha gente se me acercó y me felicitaba, y lo alucinante de ser decano es que me felicitan por cosas que yo no hago, básicamente. Porque la segunda cosa que hicimos fue empezar una conversación entre algunos de los que están aquí para ver cómo hacer esta reunión, qué temas discutir, cómo encararlos, a quién llamar para participar de los paneles. Y tengo una pequeña lista de amigos y colegas que participaron de este grupo de trabajo: Martín Bomer, Paola Vergallo, Marcelo Alegre, Marcela Rodríguez, Roberto Gargarella, Roberto de Michele, Ezequiel Nino, Celeste Braga. Y entonces quiero agradecerles mucho a todos ustedes por ayudarnos. Hay 2 de los panelistas que apenas los contactamos, uno Roberto de Michele y Martín Sabelli, vinieron de Guatemala y de Estados Unidos por sus propios medios para estar en esta conversación, así que un especial agradecimiento para ustedes 2. Bueno, finalmente, para que todo esto funcione, hay gente que trabaja detrás o a veces delante de las bambalinas. A Guido Cábana, a Paula Mangui y a Diego Barreiro, muchísimas gracias por todo el trabajo. A la traductora que se nos sumó hoy a la tarde, muchas gracias. Y bueno, para terminar, empezamos ayer al mediodía y yo empecé recordando aquel tristísimo llamado que me hizo Roberto Gargarella 20 años atrás. Y Roberto me dijo en aquel momento que, bueno, ahora iba a ser mucho más fácil despistar, porque no había nadie como Carlos para ubicarnos y señalarlos el camino. Creo que después de estos 2 días de conversación estabas equivocado, y estábamos equivocados porque Creo que en ese momento no, quizá obviamente era un momento muy triste, pero no calculamos la enorme inspiración que iba a ser Carlos Nino para todos nosotros. Y cuando digo todos nosotros es un círculo muy amplio, porque en los 5 paneles que tuvimos con unas 15 personas se notó que Carlos fue inspiración para las más variadas obras y emprendimientos que van desde los trabajos en control de corrupción al diseño institucional, la reforma constitucional, el derecho penal y una infinita agenda, los temas de género, digamos, infinita agenda que sale como borbotones de la obra de Carlos Nino, y esto se notó en los paneles, o sea, todas nuestras vidas y las de otras generaciones que están viniendo detrás nuestro están inspiradas en ese trabajo y en ese modelo. Anoche incluso escuchamos al presidente de la Corte Suprema decirnos que hasta la Corte Suprema, y esto ya lo sabíamos, no hacía falta que nos lo dijera, pero se inspira en ese trabajo, en el rol fundamental que tiene los jueces en aplicar ese límite constitucional al poder político. Tema que retoma Owen en la conferencia de hoy, y también me animo a decir que, y estas últimas palabras que agregó Owen muestran que Nino también fue inspiración para reflexiones en otros países, como en el suyo, acerca de cómo manejar situaciones como la que describió Owen en su presentación. Así que creo que nos olvidamos del lugar que iba a ocupar la inspiración que Nino iba a ser para nosotros, y de alguna manera, no digo que no hayamos despistado, pero más o menos creo que vamos por algunos caminos que él podría habernos indicado. Así que, en síntesis, tuvimos 2 días, para los que no estuvieron ayer o no estuvieron hoy, les cuento que fueron 2 días espectaculares de conversación, de discusión. Esta sala estuvo llena permanentemente durante 10 horas, 5 o 6 horas ayer y hoy. Veo gente, digamos, conocida, gente que compartió la generación con Carlos Nino, gente que fuimos discípulos y muchísima gente joven, todos estudiantes que son los que, cuando Owen casi demagógicamente se refirió a ellos, sonreían. Así que estoy seguro de que Nino hubiera disfrutado enormemente de estos 2 días, tanto como disfrutamos nosotros. Así que tener esta conversación creo que fue el mejor homenaje que podemos haberle hecho a su memoria. Así que muchísimas gracias a todos y los esperamos por aquí próximamente.